Hello, everyone. Welcome to our first webinar of the year for our employment webinar series. So thank you for joining us today, probably over your lunch break. And so today we are going to be talking about navigating employment law in 2026. So my name is Katie Busbee. I'm an employment attorney here at Haynsworth, Sinkler, Boyd. And then I have Dennard Small on our presentation today. So Dennard joined our firm in the fall, so he may be a new face to some of you, but we're going to kind of be tag teaming this presentation today. And so we kind of like to do our first webinar of the year in January. We like to do a little preview of what's happened and then what's coming up. So that's kind of what we're going to be talking about today. Just a couple of background and housekeeping things. So HSB is a full service law firm. We are employment attorneys on this call today, so we obviously deal with employment law, but we have attorneys that do really everything else in the book. I like to say the only thing we don't do is get people out of jail. That's really the only law we don't practice. But if you have any other kind of business issues that come up, our firm can help you with that. And we have 5 offices across the Carolinas and more than 120 attorneys. So please reach out to us, of course, if you have employment law help or anything else. We will be monitoring the chat today. So if you have questions that come up during the presentation, please just drop those in the chat. We'll do our best to answer those, either write you back or address it on the webinar. Sometimes we get really specific questions that tip over more into legal advice. So if that's the case, we'll just encourage you to reach out directly to us. You will get the slides after this presentation so that you can refer back to it. And then we always have to give this disclaimer on our webinars. This is an informational presentation, but it is not legal advice. So if you have specific situations or things you need help with, please reach out to us because there's a lot of nuances in these situations. So, okay. So talking about the 2026 landscape. So what are the things that we're going to be talking about today? Well, we're going to kind of hop around between topics. I do feel like these are kind of bread and butter employment law topics that we are going to be talking about today. They are things that we had maybe new cases, new laws, new regulations come out in 2025. There's also some things that we expect to happen in 2026. Of course, there's been a lot of changes as we've been in a year of a new administration. So we're going to talk about updates in wage and hour compliance. We're going to talk about some Title VII discrimination cases that came out in 2025 and some updated EEOC guidance that came out or maybe was rescinded. And then FMLA, ADA, and paid family leave. We're kind of grouping all of our leave updates into one. And then at the end, we're also going to touch on some South Carolina specifics, some bills that have been filed in South Carolina. I know probably a lot of our employers on the webinar today are here in South Carolina, but may have, of course, employees all across the nation. So we'll kind of go back and forth between South Carolina and federal and some other states today. Okay, so before we get started on all of those topics, I kind of just want to do a review of kind of the last year and what we saw take place. Like I said, we're in we've completed 1 year of a new administration. I know when we did this presentation last year, we were within the first 100 days of that administration. There were a lot of changes. I mean, I remember working on this presentation and we were literally updating it the night before as new executive orders came out and all those things. It was very busy. So we had a lot of things come out at the beginning of the year and some other stuff trickle out. And so just kind of as a review, we saw the rollback of affirmative action for federal contractors and of DEI. We saw this reorientation by the EEOC. I think that's the best term to use, where the EEOC, released a statement saying, just a reminder, there's no such thing as reverse discrimination. And the EEOC only recognizes discrimination. And what they mean by that is even when you have an employee that is part of a majority group, they can still be discriminated against. And so, you had this statement come out from the EEOC early last year on that. We had the One Big Beautiful Bill. So there was some employer deregulation in that. And then, of course, we have the deduction on taxes for overtime and tips that was a part of that bill that I know a lot of you out there are probably dealing with right now, as we're gearing up for tax season. We had the EEOC come out and say we are no longer going to investigate disparate impact claims under Title VII. And so that's different than disparate treatment, which makes up most of the things the EEOC investigates. But disparate impact, meaning an employer has a policy or practice that is neutral on its face, but maybe it is disproportionately affecting a minority group. So those are disparate impact claims. So the EEOC says we're no longer investigating those. We had the rescission or they rescinded the 2024 EEOC harassment guidance just recently. And that harassment guidance really focused on gender identity issues to help employers understand gender identity discrimination. And so that has now been rescinded. And then we also saw a lot of changes to visa programs and kind of this reorientation to focus on American workers. And there's some opinion letters that have come out about that. And so we really just wanted to give a review, and we're going to talk about some of these things today on the call. But we've really just had this shift, I think, and that's not unusual. I mean, we're really seeing that every time we have a new administration come in. There's really these big pendulum swings now. In the past couple of decades, I think we've seen more of that, and so we're really just experiencing that too now under this new administration. So, okay, we will move on to more of our updates. So, wage and hour compliance. So every year on January 1, you have a lot of states that their new laws for minimum wage go into effect on January 1. And so this is just something to be aware of. If you have remote workers, we've listed some states there that instituted increases effective January 1 this year. There are others though. So if you have remote workers in these states, this is just something to be aware of. A lot of states have laws that automatically are indexed, so their minimum wage is getting raised every year. And South Carolina, we do not have a state minimum wage, so we default to the federal minimum wage, which is $7.25 an hour. But I realize many of you probably have workers all across the country, so this is just something to be aware of as you're starting the new year. There is in South Carolina a bill that is filed every year to try to raise our state's minimum wage, but historically that bill doesn't usually go anywhere. So just keep that in mind as well. Okay, so let's talk about FLSA salary thresholds. And I wanted to include this, or we wanted to include it because I think we are getting some questions from employers on this. I think there's some confusion around some proposed rules, a raise that was proposed in 2024, and then another raise was supposed to go into effect in 2025, and those did not go into effect. A federal court actually struck that rule down, those proposed increases. And so I think we are getting some confusion from employers like, well, don't we have a higher salary threshold now? And the answer is no. We've actually reverted back to $685 or $684 a week, which was the level that was in place before all of these proposed increases. And so those increases didn't go into effect. And so this is just something to keep in mind. Of course, for your FLSA exemptions, they have to be salaried. They have to meet this $684 a week. And then they have to meet the duties requirements of one of those exemptions. So just kind of a reminder of where we are on that. Another thing to be aware of is that some states also have salary thresholds that for workers in those states, they have to be making a certain salary to not be paid overtime under state law. And so a lot of these states have actually much higher salary thresholds than the federal threshold. I think the new increase for Colorado, correct me if I'm wrong, Dennard, I think it's around 80,000 a year. So some of these are, I mean, over double the federal level. So this is just something to keep in mind. If you've got remote workers in those states, you want to make sure that you are classifying them correctly, that you are paying them overtime if they need to be paid overtime. Okay. So a little reminder, this is not a change in law, but and this is something specific to South Carolina, although other states do have similar statutes. But I am seeing this come up with some of our clients, and I think it comes up a lot in the context of sometimes when you're moving an employee from non-exempt to exempt. But South Carolina does, under the Payment of Wages Act, have this statute that requires employers to notify employees in writing at the time of hire of certain things. So their hours and wages agreed upon, time and place of payment, deductions, including payments to insurance programs. So at the time you're hiring people, your offer letter, you need to make sure it has this information in it, that they are getting that in writing. And then what some employers I think maybe don't keep up with is that if there's any changes to those terms, you have to notify them in writing at least 7 calendar days prior to that change. And so this comes up most often in wage changes. If you are decreasing somebody's wages, you have to notify them in writing at least 7 calendar days in advance. But it actually applies to any changes in that list right there. So you're changing their hours, any of those things. To comply with the statute, you've actually got to do that in writing 7 days prior. So this is just kind of a reminder. I'm seeing this come up with employers who are reclassifying their employees. Maybe they're moving from non-exempt to exempt. Well, a lot of times that results in a pay change, and it may be a pay decrease because if they're going from getting overtime pay to not getting it, that's something you need to notify them in writing 7 days in advance, I think, to meet the statute and make sure we're not giving any room for an argument there. So this is just kind of a reminder. It's a requirement for South Carolina, but there are also some other states that have a similar statute. Okay, so no tax on tips or overtime. So this is a part of the One Big Beautiful Bill that passed last year. It's something that I think a lot of you are probably having to deal with right now as you're getting out your W-2s or maybe answering questions from employees. And so this is a new deduction for tax years 2025 to 2028 for overtime and qualified tips. For the overtime portion of that, it is a deduction on that half premium that they are getting for overtime. So of course they get paid 1.5 times their regular rate for overtime. That half is what is included in this deduction. Those are the wages they're going to be able to deduct. So the max annual deduction for tips is 25,000. For overtime, it is 12,500 for single filers, and then 25,000 for married filing jointly. Um, so this is something they can claim for 2025. So, they may be coming and asking you for information to be able to track those wages, what they were paid on that premium. And so, this is something you probably want to be talking to your payroll provider about. How is it best to pull this information? Do we have this? And then beginning January 1, 2026, employers actually have to report that information on a separate box on the employee's W-2. So again, you're just wanting to make sure that, you're talking to your payroll provider, you're reviewing your internal systems to make sure that you are capturing the wages for that premium on the overtime so that you're able to comply with this. Okay, we had in 2025 a little relief for employers that came out. So this deals with liquidated damages in wage and hour disputes. And so previously the Department of Labor, it hasn't always been done, but I think in the last couple decades, the Department of Labor in their investigations in wage and hour disputes and kind of their pre-litigation settlement arrangements, they have been seeking liquidated damages from employers that violate minimum wage and overtime laws. And so liquidated damages means doubling basically the back pay that you are owed to that employee. So liquidated damages is allowed under the statute, under the FLSA, but the Department of Labor started enforcing these in pre-litigation disputes. So when they were doing their investigations, they were requiring employers to calculate this in their cost to settle, basically. And so the Department of Labor announced last year that they're no longer going to seek liquidated damages in their own investigations in these pre-litigation settlements. And so really what you need to take away from this is just a kind of a small win for employers. I think it's going to bring down the cost for employers to settle with the Department of Labor and to bring these administrative proceedings to a resolution before they go into litigation. If an employee does sue or the Department of Labor brings suit on behalf of the employee, they can still seek the liquidated damages at that point, but it gives the employer a small win kind of before you get to that litigation in hopes that you can settle before that happens at a reduced rate. Okay, so we had a couple of DOL opinion letters come out last year in wage and hour. And so this letter is probably something that a lot of you are aware of, but I think it's worth reminding you all. But the employer asks, if an employee is basically exempt, their duties meet the duties requirement. If they're salaried, their salary is high enough to where they would be exempt. Can an employer still choose to pay them hourly and pay them overtime and make them non-exempt? And the Department of Labor said, yes, of course. If you want to pay your employees overtime when you don't have to, that's fine with us. So, this is just a reminder that you can have an employee that would maybe be exempt as long as you're paying them a salary, they meet the duties requirements, they would meet the salary threshold, but you can choose to pay them hourly and make them non-exempt. And so, the inverse of this is the warning that, just a reminder, if you're moving them from salary to hourly, they are going to be non-exempt. And so, they can't be exempt and still be paid an hourly wage. So a little update from the Department of Labor on that. Okay, we also had a case that was decided this year that was also kind of a small win for employers. So basically, this was a case that that the Supreme Court said it clarified the burden that employers have to meet when they are proving why an employee is FLSA exempt. And the Fourth Circuit had imposed a higher burden. It basically had said if an employer classifies an employee as exempt, if that's challenged in court, the employer has to present clear and convincing evidence to show that that employee is classified properly. And clear and convincing is a higher bar, it's a higher evidence requirement than preponderance of the evidence, which is the normal burden in your civil cases. And so the Supreme Court said, no, we're not going to allow courts to impose this higher burden on employers. The FLSA is silent on what burden is placed on the employer to be able to show that the employee is exempt. And so until Congress amends the FLSA and changes that, we're not going to allow courts to impose this higher standard. And I apologize, my lights turn off automatically in my office. I'll get that back on. So anyways, this just lowers the standard for what employers have to show when they're making their case for why an employee is exempt. So this is I think a good win for employers. Okay, so those are our wage and hour updates. I'm going to kick it over to Dennard, and he's going to cover our Title VII discrimination cases.
All right. Good afternoon, everyone. I just want to echo Katie's sentiments. Thank you all for joining us. I'm going to talk about some discrimination cases and some EEOC guidance. I'm going to start off with the EEOC technical assistance that came out in November of last year. The title of it is Discrimination is Against American Workers is Against the Law. It's a simple one-page bulletin, but it does three things. First of all, it reiterates that Title VII protects all workers. Second of all, it talks about what anti-American national origin discrimination could look like. It gives a few examples. First thing it does is it prohibits H-1B only postings. So job postings that specifically outline that they're only for H-1B applicants, that's now a per se violation of Title VII's advertising rules. Second, it clarifies that preferring H-1B holders over qualified Americans is a form of national origin discrimination. And third, it says that terminating American workers who are, quote, on the bench, so they're in between assignments, while retaining an H-1B holder who's in the same situation is now evidence of discrimination. The other thing that this technical assistance document does is they clarify that there are a few common business reasons that no longer justify national origin discrimination. So employers can no longer say that, hey, H-1B employees are cheaper to hire. They can no longer say that H-1B employees have a better work ethic, or they're more loyal because they depend on the visa. And you also can't use client preference and say that our client prefers a team from country X or a team from country Y. The EEOC now rejects those as justification for national origin discrimination. I also want to touch on Project Firewall, which is a collaboration, a partnership with the Department of Labor. Now, if the Department of Labor finds an H-1B wage violation during an audit, they're going to automatically report that to the EEOC, and they're going to open a discrimination case. So be aware of the new realities surrounding H-1B visas. I also want to talk about this. This happened just last week, actually. So the EEOC just rescinded their harassment guidance, which was originally approved in 2024. They are shifting their focus away from sexual orientation and gender identity harassment toward biological sex protections. And that aligns with Executive Order 14168, excuse me, which directs federal agencies to protect men and women as biologically distinct sexes. Some of the things that the 2024 guidance explicitly labeled as violations that have been that are now rescinded: misgendering, which is repeating and using the pronoun that's inconsistent with their gender identity, denying access to bathrooms consistent with someone's gender identity, outing someone, which is just disclosing their sexual orientation or their gender identity without their permissions, and then trying to enforce gender-specific dress codes on transgender individuals. Those are no longer explicitly Title VII violations. The new priorities for enforcement are privacy rights, binary interpretation, and then narrowing the Bostock decision. So I want to talk about a Supreme Court case. It is from 2024, but it's kind of got a big impact. It's Muldrow versus City of St. Louis. A little background on the case. Sergeant Muldrow was a plainclothes officer in the St. Louis Police Intelligence Division, and her commander transferred her to a uniform patrol division in a different district. Her rank and her base salary stayed the same, but her schedule changed. It now included weekends. Her duties changed from to patrol duties versus a high-level intelligence duties. She lost her take-home car, and her prestige and her networking opportunities were changed. So the lower courts dismissed that case initially, arguing that because her pay and her rank were unchanged, she didn't suffer a materially adverse or significant employment action. The Supreme Court, in a unanimous decision, vacated that ruling, quote, and clarified a new standard, quote, an employee challenging a job transfer under Title VII must show that the transfer brought about some harm, but that harm need not be significant. So that's important because they've rejected the significant harm standard that was the standard for decades. Most circuits, including the Fourth Circuit, required a materially adverse action to sustain a lawsuit. Muldrow has ended that requirement. So the new standard, some harm. In order to win, a plaintiff only needs to show that they were left worse off in some way. And that can include economic harms like changes to prestige, schedule changes, or even changes in job responsibilities. So reassignments and merit-based diversions, even if they're non-economic, are now potentially actionable. And I actually want to discuss a few cases on the next slide that just follow along this Muldrow line. So first, I want to talk about Muldrow. Muldrow was a Title VII case, but the Fourth Circuit last year in August ruled on a case called Herkert versus Bisignano. Sorry if I mispronounced that. A background on that case. Well, that case was in that case, the Fourth Circuit applied the same some harm logic from Muldrow to the Rehabilitation Act, and by extension to the American with Disabilities Act. Mary Herkert, she was a branch chief at the Social Security Administration. She had multiple physical disabilities, and she requested a telework arrangement as an accommodation. So her request was initially denied, and she signaled that she intended to file an EEOC complaint, and the Social Security Administration reassigned her to a management analyst position. The new role allowed telework, and her pay and her benefits remained the same, but she went from being a supervisor of many people to a non-supervisory role, and she described that position as having less prestige and fewer advancement opportunities. So using the old significant change, materially adverse employment action rule, the district court threw that out, and the Fourth Circuit vacated that decision, explicitly adopting the some harm test from Muldrow. They said that Herkert didn't need to show a significant or material disadvantage, and that losing her supervisory duties and the lack of professional prestige was enough to constitute some harm. The employer actually also argued that Herkert accepted the transfer and even said thank you, so then it couldn't be discriminatory, and the courts also disagreed with that. They said if an employee is presented with, hey, this is a done deal, or if they're presented with a choice between two least worst options, then that's for a jury to decide if that transfer was truly voluntary. So takeaways from that case, I would say the old kind of thought process was that if I can't accommodate an employee in their current role, I'll just move them to a lateral role. Under Herkert, if that lateral role has less prestige or supervisory authority, that's now actionable. The employee can now sue for discrimination, even if that's the exact accommodation that they asked for. And then I just want to dispel the gratitude myth, if you will. Just because an employee says thank you for a transfer doesn't make you safe from a lawsuit. The court in this case looked past that initial thank you, and they looked at the fact that she felt she had no other choice to keep her job. So just practical strategy for you guys based on this one. If you're reassigning an employee's accommodation, you should now document not just the medical fit, but look at a side-by-side comparison of the non-economic terms, their supervisory duties, their title, their office space, their potential career path. And if there's any step down in any of those realms, be upfront with the employee during the process and get a signed acknowledgement that they understand the differences and they're choosing that transfer over other available options. The other case I want to talk about is Martin v. Stateside Association. So this is not a South Carolina court decision, but Virginia is in the Fourth Circuit, and I think it's kind of instructive of how judges have immediately kind of become skeptical of it was just a lateral move defense when there's a loss in prestige or a loss in actual work. So background on Martin v. Stateside. Melissa Martin was a high-performing senior director at Stateside Associates. She alleged that her workplace became brutally toxic, specifically targeting female employees. In August, she lodged a complaint about the abusive work employment with her employer. She described the environment to another senior principal who initiated an internal investigation with their legal counsel. She met with their legal counsel and provided a signed statement in September. She highlighted that her supervisor regularly lashed out by screaming and slamming his fist on the furniture, and that these outbursts were mostly directed at her and other female staffers, but never male staffers. She also cited instances where the managers derided her divorce status and her academic credentials, which created a gendered hostile environment. So in October, she was kind of given an ultimatum where she could continue to work on the team led by the allegedly abusive director, or she'd be reassigned to a special projects role. She accepted that transfer and she was moved to the new role, which came with a prestigious title, but she alleged that she was effectively shunned. She was given little productive work to perform, and that she was replaced in her previous role by a male manager that had no regulatory experience. She continued in that role until April. She resigned, and informing her employer that she felt that she was constructively discharged, filed an EEOC claim, and she brought suit. The employer moved to dismiss, but the court allowed the case to proceed, saying that the hostile environment and her perception that she was shunned in the new role could lead a reasonable person to believe that they had no choice to resign. So following the logic of Herkert, this case specifically, it kind of emphasizes that a lateral transfer isn't necessarily safe just because the pay is the same. If you move an employee to a role where they're shunned or where they're given no work, that can still constitute some harm under this new Muldrow standard, and that can support a claim of constructive discharge. Um, I think this case is also great in pointing out the importance of internal investigations. Part of the court's reasoning is that she alleged that she provided names of coworkers who could corroborate her claims, and the HR investigator failed to interview them. It's internal investigations are really important. So, I just wanted to highlight that for you guys. We got some questions before the webinar, some submitted questions. So this first one came from Kelly, and I want to answer this here. Kelly asked, how should employers adjust their internal complaint investigation processes in light of the new EEOC trends? Uh, Really, the EEOC rescinding their harassment guidance and their clarification about the reverse discrimination, it shouldn't really change how you guys are conducting your EEOC investigations or what you're investigating. The holding in Bostock still stands. So you have to investigate gender discrimination, harassment. You should just not consult the new guidance that's been rescinded, the 2024 guidance, for example, that's been rescinded. You should also continue investigating harassment and discrimination complaints from individuals in majority groups, which the EEOC in Title VII has always required. So just remember, courts consider EEOC guidance in their decisions, but the EEOC guidance really isn't the law. So now we're going to talk about FMLA, ADA, paid family leave. Like Katie said, we kind of grouped all of the leave together because they kind of overlap. So there's some new Department of Labor opinion letters that came out on FMLA at the beginning of the year. The first one, the question is, how do snow days or emergency closures of 1 to 3 days affected employees' 12-week leave bank? So the specific case in question with this one, it was a school. There was an employee that was taking FMLA leave, and during their leave, there was like a 3-day closure for a snow day. So they asked for clarification on how that affects their 12-week leave bank. The FMLA the DOL gave us kind of a two-part answer. First, they gave an example for an intermittent week or a partial week. So if an employee is using FMLA for a doctor's appointment on a Tuesday afternoon and the office closes all day on Tuesday because of a winter storm, the hours, those closure hours cannot be deducted from their FMLA entitlement. Because the employee wasn't expected to work during the closure, they technically didn't take the leave. On the flip side, they offer the full week rule, and the example they give is that if an employee's out on FMLA for the entire week of January 12th, and the office closes for Wednesday and Thursday due to an ice storm, the entire week is still deducted from the employee's FMLA bank. In this scenario, where the employee's taking an entire week, their FMLA is measured in weeks. So, and this kind of matches up with the long-standing rule for holidays. So it's aligned with previous FMLA guidance, and in my opinion, this kind of makes sense. The DOL also clarified some irrelevant factors. There were specific questions about if the reason for closure was an emergency or if it was planned maintenance. If that matters, that is irrelevant. It doesn't matter if it's closed for a day or two because of an emergency or if it's a planned closure. The intermittent rule and the full week rule still apply. Their leave bank is still either affected or not affected based on whether they were taking a short term or less than a week type leave or whether they were taking a full week. And there was a follow-up question about whether makeup days scheduled later in the year changed that analysis, and the Department of Labor said no, that's also an irrelevant factor. Even if, like I said, the original example was a school. So usually when you have a snow day, at times there's makeup days that they add at the end of the year. That's irrelevant. If the employee was not entitled to work on that day, you still follow the intermittent rule or the full week rule based on the type of or the length of the FMLA leave they're taking. So on the same day, we got another FMLA opinion from the DOL. This one's pretty simple. The rule that they laid out, the time spent traveling to and from a medical appointment for a qualifying serious health condition is protected FMLA leave. The question was, hey, this employee has a medical appointment. Do we give them just the time that they're at their appointment for leave, or do we include travel time? So the Department of Labor clarified that protection includes reasonable travel time to the provider, the duration of the appointment, and the return trip. This rule also applies to the employee's own condition. This applies to the employee's own condition, or if they are caring for a covered family member. For example, if you have to take a covered family member to an appointment, that travel time is also protected FMLA leave. So basically, once the doctor certifies the need for the appointment, the travel is considered part and parcel of that. But to be clear, the DOL did specify that employers cannot require the healthcare provider to specify the exact travel time required in the medical certification form. But employers may discipline employees who take extra time that's clearly unrelated to the medical travel. Just because the travel time is included doesn't mean that employees are given leave to stop and run personal errands during this time or to have lunch. That needs to be taken separately and not counted as a part of their leave. So employees that try to take advantage of that, employers are still able to discipline them for that. And then I want to talk about a very recent case. This case actually was just heard or was just ruled on by the Fourth Circuit in January, last week or the week before, I believe. It's called Haggins versus Wilson Air Center. Background on it, an accounting assistant was diagnosed with a form of breast cancer during COVID. She was originally allowed to work fully remote, but as the business came back, they requested that she return to work on a flex schedule because they had essential in-person duties, the filing of paperwork, and there were certain things that she was not able to do remotely. So they were very accommodating. They tried to make this flex schedule work around when she was able to come in, and she agreed to the flex schedule. But then she repeatedly failed to show up to the job or communicate any of her absences. And Wilson Air eventually terminated her for job abandonment. Excuse me. The Fourth Circuit clarified that Haggins was not a qualified individual under the ADA because her role required some in-person work, and she failed to act after agreeing to the flex schedule. She failed to actually attend, and she failed to communicate. The court actually praised the employer in this case, saying that they exceeded the call of duty because they continued to work with her during this time. It was about a 3-month period, and they excused a lot of her failure to communicate. To clarify, Ms. Haggins showed up to work for 2 partial days total in a 3-month period, and the employer, was very open and very accommodating and tried to work with her during that period. So the court actually praised the employer for their resilience, and Ms. Haggins' retaliation claim also failed because she was not able to show a causal link between her HR complaints and the termination. There was well documented that she was terminated for non-communication and failure to return to work. Takeaways for you guys: telework can be a reasonable accommodation, but it's not an absolute right. If there are essential in-person components to a job, persistent failure to report on a hybrid schedule can actually disqualify that employee from the ADA protections. Like I said, the court praised the employer for their for continuing to work with the employee. So I know sometimes I've heard from employers and they say, hey, maybe I shouldn't have been so nice. But actually the court, the court liked the court, it actually helped their case that they provided leave beyond what was required and that the employer was actually so accommodating. Of course, the documentation was important. But that just for anyone who thinks that you shouldn't be so nice to people and try to accommodate, the courts actually find that their courts have actually recently showed that that can help your case.
Okay, I think I'm going to jump in here and cover the next couple of cases. So this is a Fourth Circuit case that I think it's a good one to talk about because we have a lot of questions about employees coming back from FMLA and then needing more time, leave as an accommodation under the ADA. A lot of times those are overlapping. And so this is a case where an employer provided 12 weeks of FMLA. This employee was out from like February to May on FMLA. They ended up ultimately providing her 12 more weeks as an accommodation under the ADA. But that at the end of her FMLA, they reached out and of course said, hey, when can you return? She responded and said, I can't come back. I've got these, I may be able to come back in August, but I've got these other surgeries lined up in September and October. I'm going to need time to recover from those. And then she told her employer, don't ask me again when I'm coming back. It was kind of a aggressive email. And so the employer, again, kind of to Dennard's point, did actually work with her. They continued to give her unpaid leave as an accommodation, knowing that she had a follow-up appointment in August and that she might be able to come back in August. But when August came, she still did not return. They terminated her. And so, of course, she sued for failure to accommodate and then, ADA discrimination and some other things. But the court held that employers do not have to grant indefinite leave under the ADA as an accommodation. And so the court said nothing in the text of the reasonable accommodation provision requires an employer to wait an indefinite period for an accommodation to achieve its intended effect. Rather, reasonable accommodation is, by its terms, most logically construed as that which presently or in the immediate future enables the employee to perform the essential functions of the job. And so the court basically said that when even though she said, hey, I may be able to come back in August, this uncertain response, or maybe I'll be released in September, October, was too uncertain for the employer. It was certainly not in the near future, and indefinite leave is never a reasonable accommodation. And so this is also discussed in the EEOC guidance for accommodations that you do not have to grant leave indefinitely to an employee. But I do think this comes up a lot in the context of you have employees that say, well, I have a doctor's appointment in a month. And, at my doctor's appointment, I may get released to come back. And it does place employers kind of in this catch-all. Well, it's still uncertain. We don't know if she can come back in a month or he or she. And so I think this case does help support the notion that, if you get that uncertain response from the doctor or the employee, it's not reasonable that you have to provide that leave as an accommodation. But of course, these can vary by circumstance. So if you have this situation come up, please reach out. Okay, another Fourth Circuit case that came out last year. This was a COVID-19 vaccine case. And so, a lot of these cases where employers required their employees to get the COVID-19 vaccine, a lot of lawsuits that resulted from that are just now making their way through the court system. And we got this decision this year. And this was a situation where this employee was an engineer and her employer had made a mandatory COVID-19 vaccine requirement. So all of their healthcare workers had to get the vaccine. And she requested an exemption from this requirement as an accommodation. And she said that her Lyme disease caused immune dysregulation and that she could not get the COVID-19 vaccine because of this. The employer asked for medical records. I think she originally submitted a doctor's note that was like 9 or 10 years old saying that she had Lyme disease. And the employer said, hey, we're going to need an updated letter. This is, old at this point. And she came back and she gave them some information about how Lyme disease, she couldn't get the vaccine because of her Lyme disease. But she wouldn't sign a HIPAA release. So she wouldn't let the employer clarify with her doctor how the Lyme disease made the exemption necessary for her. And when they reached back out to ask for more information from her doctor on it, she refused to participate. She basically refused to go back to her doctor to get more information on how the Lyme disease was connected to her need for the accommodation. And so they did not accommodate her. And when she refused to get the vaccine, they terminated her. And so she, of course, sued for failure to accommodate, ADA discrimination, and other claims. But the court said that in situations where the employee's disease and the need for the accommodation is not obvious, the employee has a duty to provide the documentation that the employer is asking for to figure out if they actually need that accommodation. And because this employee refused to participate in that process, she obstructed the interactive process. And so, I think this is a reminder that there is a concept under the ADA that says, or there's a requirement where an employee has an obvious disability and the need for the accommodation is obvious. You can't require them to go get a doctor's certification. And of course, like the easiest example of that is if you have an employee in a wheelchair and they're needing an accommodation that makes sense because of that wheelchair, you can't require them to go get the doctor's certification to justify the accommodation. But most of the time, that's not what we're dealing with. We're dealing with employees that have non-obvious disabilities, and the accommodations are not so obviously linked to their disability. This employer did not understand why Lyme disease prevented her from getting the vaccine. So employers can ask for that information, and if the employee obstructs that process, they are actually no longer qualified under the ADA. So I think that's the takeaway from that. Next slide. Okay, so I just want to quickly go over some ADA accommodation best practices coming off these cases. So employees should have a somewhat certain return to work date. An indefinite leave is not reasonable. And the reason I say somewhat certain is because the court, and there is some ADA guidance that says, whether the employee returned on August 10th or August 15th maybe doesn't matter, but that is a somewhat certain time frame. It's maybe in the immediate future, kind of going back to that case. And so they need to be able to provide something that is somewhat certain, even if it's not the exact day, because otherwise a lot of uncertainty for the employer is just indefinite leave, and that's not reasonable. You can require a doctor's certification for non-obvious disabilities or accommodation needs. You cannot do it for obvious disabilities and accommodation request. You do have to engage in the interactive process, of course. I feel like I'm hearing, I do hear from our clients, and I understand the frustration when we kind of start down this ADA process. And, I think there's you're tempted to say like, oh, we go down this process, now we got to go through this whole thing. It's going to be months and we got to have all this back and forth. And I mean, yes, to an extent that's true. That's why it's called the interactive process. There is going to be back and forth with that employee. There is going to be them going and getting that certification from the doctor. That is part of that interactive process. And so, you have to make sure you're doing that and that we can show that you did it in your communications. Accommodations have to be determined on a case-by-case basis. So if you have multiple employees asking for the same accommodation, I'm thinking of a lot of our employers that are bringing their employees back from work from home. You have to evaluate that on a case-by-case basis. So what works for one employee, you may be able to grant it in that case, you may not be able to grant it in the other. And just a reminder that mandatory leave policies violate the ADA. Sometimes I have clients tell me, sorry, I'm gonna turn my light on again. We have a very sustainable office. Sometimes I have clients tell me, well, as a kind of an internal policy, we always give like 4 weeks of unpaid ADA leave. And while I understand what they're saying, I mean, that's a mandatory leave policy. I would say you can tell me that, but don't tell anyone else that because that actually violates the ADA. You've got to be going through this case by case process and determining whether leave is an undue hardship or not in this case. Keep a log of every call, email, attempt to accommodate so that we can show that if it's challenged. And you do not have to grant the accommodation they request. You can work with them through that interactive process to find an alternative accommodation. But the alternative accommodation does have to address the limitation. So just keep that in mind. Okay, and I'm gonna skim over this, I think for time, but this is just kind of a reminder that again, as we start the new year, there are some states that are upping their paid leave or they're implementing paid leave, paid family and medical leave. In South Carolina, we do not, for private employers, we do not have paid family and medical leave. And then, of course, the federal government does not have paid family and medical leave, but some states do. So if you have remote workers or you have employees in these states, you just need to be aware that, again, January 1, a lot of times these states increase their leave entitlements or they're now offering paid leave. Okay, so with that, I'm gonna kick it back over to Dennard.
So I'm going to touch on a few South Carolina specifics. This is pending legislation. This is kind of a critical time because any bills that don't pass before May 14th, they effectively die and they have to be reintroduced next year. So these are just some employment-related bills to look out for. First, I want to talk about House Bill 4750, introduced at the beginning of the year, currently in committee. The goal of it is to require insurance carriers to provide a standardized disclosure when they're denying a claim. The bill sponsors kind of argue that injured workers often misunderstand the role of the insurance carrier. Sometimes they mistakenly believe that the carrier is an advisor, as opposed to the carrier is actually a representative of the employer's interests. In this bill, they want to require insurance carriers to provide them a notice that says clearly the carrier is not an advocate for the employee. To let the employee know that, hey, the employee has a right to their own attorney, and to let the employee know that they have a right to appeal to the commission. So if this does pass, HR team or the third party authorizers will need to audit your workers' comp intake and your denial templates, but that will go into effect at the beginning January 1st, 2027. Proactively, you could review your policies in your handbook, and all of these things still apply. You can add a process transparency section that kind of explains the carrier's role and clarifies to employees in your handbook that the carrier is not their advocate. They have a right to an attorney, and they do have a right to appeal to the commission. Next bill, House Bill 4751. This one I think is really interesting. Also introduced at the beginning of the year, also in committee. Their proposal is for daily overtime. So, daily overtime and for single work week overtime. So overtime would start would start on any day that the employer works over, or the employee, excuse me, works more than 8 hours in that day. The 1.5 times rate would apply, or the 1.5 times rate would apply in any single work week where an employee works more than 40 weeks. It's an interesting proposal. It will likely be costly to employers to implement and require some changes in the way that that the time is managed. They have proposed an alternative work week, so the employer would be able to sign a mutual written agreement with the employee for 4 by 10 schedule, 4 days, 10 hours a day. So where the daily overtime would only kick in after the 10th hour of a workday. Um, some of the explanations that kind of explain that, you can work on a 4x10 and you could work 8 hours the first day, 8 hours the second day, 6 hours the third day, 4 hours the fourth day, and then another 6 hours the fifth day. That math probably doesn't equal 40, but you would be able to stretch that out over a 5-day work week. Like you could schedule it that way, but it's still a weird. It would involve a lot of changes to the way that we currently think about overtime, both daily overtime or single work week. This bill would also explicitly ban any unpaid trial periods, unpaid training periods, unpaid break-in or initial employment periods. Any of those, it would basically say that any time an employee is working, they are to be paid, and you can't start their employment off with a 2-week or 2-day kind of break-in period or training period where they're not paid. The next bill kind of follows up on that, or is kind of aligned with that. It's House Bill 3368, which proposes to exclude overtime pay from South Carolina state income tax. This is kind of in line with the federal bill. I don't actually know. I don't know what the thresholds are going to be, or if it's going to be to completely exclude overtime pay from state income tax. But this is the trend that they're following federally. So the House is considering implementing that at a state level as well. And that's it for the employment-related bills that are pending. I think we're actually pretty close to time. Questions, comments, concerns? We'd love to hear from you.
Yeah, I think I've answered our couple in the chat. Somebody was asking about the FMLA entitlement when you have a closure. So again, if that employee is taking a full week of FMLA, so they're taking more of a continuous FMLA, any closures would still be counted against their entitlement if it's like a snow day or emergency closure, something like that.
Yes.
If they're taking intermittent or partial week, it would not, because they wouldn't have had to work that day. So that's the clarification there. I think we had a question on, do you know how the daily overtime would affect 12-hour shifts? I think they are talking about the bill that's been introduced in South Carolina.
That's sort of unclear. I think that may be a situation where that alternate work week exception would fall in, where you would agree to be on a kind of a 4x10 schedule, and then the daily overtime would then only kick in after the 10th hour. But like I said, if that passes, it would really change the way that employees think about overtime, that employers think about overtime. So we're going to continue to keep an eye on that, and stay tuned to our blog, the SC Employment Law blog, for updates on that.
Okay, and I think that's everything. I think we answered all the ones in the chat. So thank you for being with us today. We'll let you go 1 minute early. Again, you will get these slides, and we'll be sending out some information for our February webinar. So thank you, everyone. Happy New Year.
Thank you, guys. Happy New Year.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.